So this paper describes categorically how technology in the field of any dispute resolution, including commercial disputes, can be used in terms of effectiveness. So now we'll move to some technical aspects of such things. Like I'll go for some technical notes on online dispute resolution. That is a descriptive document by United Nations. That is a UNCITRAL technical notes on ODR, and section 5 defines ODR, and it defines it as the mechanism for resolving disputes through the use of electronic communications and other information and communication technology, and it may evolve over time. So this is the very descriptive basic definition, and it further provides that ODR, this is the most important aspects, that ODR requires a technologically based intermediary. Unlike offline dispute resolution, if we go for ADR, so it uh, requires a technologically based intermediary, like the dispute resolution cannot be on ad hoc basis. It involving only two parties, like negotiation. It will involve a third party, a neutral, that is to permit the use of technology to enable dispute resolution process. And ODR requires a system of generating, sending, receiving, storing, exchanging, or otherwise processing communication in a manner that ensures data security. And such a system is referred as ODR platform. So basically we need a platform that is can be that for there are two disputing parties, like one uh, for example we have if I'm just giving an example, like if some kind of dispute arises uh, between me and Flipkart is the seller, and the dispute arises between me and the Flipkart. So it is not that only Flipkart and me would be involved. There would be an ODR platform for dispute resolution. Like I will be sending the email, or if they have developed a particular kind of software, all the information would be stored over there. So it is that a third party involvement would be there for sure, even if we are using a software for ODR. Then further, an ODR platform should be administered and coordinated by an ODR administrator. That is the entities that carries out such administration and coordination. And then we have the ODR communication through which we communicate. So, and to communicate efficiently, we need ODR administrator and platform, and the ODR platform to uh, work in sync with each other. Then moving further, uh, I've quoted some part of the speech by our former Chief Justice of India uh, on the occasion of an international conference on arbitration in the era of globalization. Honorable Mr. Justice Bobde, the former CJI, he pointed out some relevant concerns and issues to make India and international hub of arbitration. And for that, he said that we need international arbitration and artificial intelligence for making India an arbitration hub for international dispute resolution. So further, I would like to move towards the conclusion that there are Supreme Court of India has set up Supreme Court Vidhik Anuvad software. It is an artificial intelligence powered translation engine that translates judgment from English to Indian languages. Like in Supreme Court, we have this major problem that the entire nation is looking for justice to Supreme Court, but we have this language barrier that is usually seen, and for that we have this Supreme Court has developed this Vidhik Anuvad software from translating judgment to Indian local Indian languages, because we have people from all over India, which with over so many dialects and languages, and it is impossible for them to know everyone to know English in our country still. And then we have a report of high level committee on deepening of digital payments in 2019, and that committee suggested that such ODR platform ODR should have two levels. It is one automated and one human operated, with a provision to appeal. So this is a very practical aspect. Like if we have any software for dispute resolution, or it should be two leveled, or always two leveled, one through technology and one governed by the human resource, in which we have a provision to appeal. Like appeal gives us a right. It is a way in which not only the justice is delivered, but justice is ensured to appeal. Like if from a lower court, if we can go for appeal to a higher court, it ensures that we are getting justice in right terms, not for the namesake. So that goes for commercial disputes as well. So then there were some particular cases that I had pointed out, that we had pointed out along with my author, at state of Maharashtra versus Praful Desai in 2003. It was upheld the validity of video conferencing as a mode of taking evidence and testimony of witnesses, and it went to call virtual reality the actual reality. So though that was way back in 2003. Then I also mentioned few more: Grid Corporation of Odisha Limited versus AES Corporation 2002 case. In this, court held that if consultation could be achieved through electronic media and remote conferencing, it was not necessary for people to sit with each other in the same physical space. Then there was Messrs. Meters and Instruments Private Limited versus Kanchan Mehta 2017 case. It was observed that there was a need to have category of cases which can be partly or entirely concluded online without physical presence of the parties, and recommended that resolution of simple cases like traffic challans and check bouncing should be done through video conferencing only. The court further recognized the validity of online arbitration. Then another one, we have Shakti Bhog versus Kola Shipping. There are very and one Vedanta Aluminium Limited case, that is in 2009 2010 respectively. In both these cases, the court held that online arbitration agreement is valid as long as it is compliant with section 4 and 5 of IT Act 2008, read with section 65B of the Indian Evidence Act 1872 and provision of Arbitration Conciliation Act 1996. Now the legislative preparedness that we have is section 65A, 65B of Indian Evidence Act, that allows for recognition of electronic evidence, then recognition to digital signatures under section 4, 5, 10A, 11 to 15 of IT Act, and to provide validity of online contracts. And this has been enabled through adopting UNCITRAL model law in electronic commerce in 1996 and model law in electronic signature in 2001. Now the requirements for effective ODR mechanism, like these are some of the prerequisites that we need, that the awareness that this works. Then secondly, technological tools, strong internet, mutual trust, trained professionals, secure channels, user friendly platforms, enforceability of outcomes. Like this is very, if we go legally into it, all these things go hand in hand, because if people are not aware, they'll not trust the system. Then we need a strong internet connection for that, like having data and electricity 24/7, or at least during the time that we are dealing online for dispute resolution. Then we should have secure channels that cannot be hacked, then that user friendly platforms that are easy to operate. Then we should have trained professional, like if we have a dispute, we two lawyers are sitting in different cities, they should know how to operate basic no they should know the basic operating rules of a or the basic operating mechanism that works for a computer or even for a phone. Then they should have the mutual trust that the outcomes that we are getting through online dispute resolution, they are enforceable. So as the future of ODR in commercial dispute in India, it is rightly put by Richard Susskind, uh, who propounds that access justice uh, can be seen into four layers. First, legal health promotion. Second, dispute avoidance, dispute containment, authoritative dispute resolution. So during COVID-19, judiciary of the country has systematically employed technology for resolving disputes and keeping the court system alive virtually. So we are on the track, but yes, it is a distant reality for say still. So for some, uh, because the the problem of electricity and getting data and internet connectivity is still a problem in rural areas. And dispute, as you know, okay, that dispute could arose at any part of the nation. So we should have these facilities all over the country uniformly. So with this, I would like to end my presentation. Thank you.